Hello and welcome to the Save Our Sperns podcast, Voices from the Frontline. My name is Morella Fife, your host and member of the Save Our Sperns team, and this podcast comes from the Spurn Mountains in Northern Ireland. This is an ancient land shaped by mountains and bogs and by the communities born from them, and whose same peoples are now living with growing pressures from mining and large-scale upland industrialisation. That pressure isn't unique to here. Across the world, the so-called energy transition is driving ever more extraction. There's growing demand for critical minerals and rare earth metals, and that demand is landing on local communities, asking them to live with the long-term impacts of toxic mining. Season 1 looked at why the Spurn Mountains matter through the voices of the people who live here and know this place well. Season 2 keeps those local voices at the centre while also stepping back a bit. In Season 2, we look at extractivism more broadly, how it's been justified, how it's fundamental to a system of accelerated growth, plundering ever more from a finite planet designed only to feed predatory capitalism, creating untold and unprecedented misery simply to support the bottom line of a balance sheet in some distant glass-walled boardroom, far from the ground we're standing on. Thanks for listening. Let's begin. Today I'm speaking with Laura Neale. She is an environmental lawyer working with Friends of the Earth, Northern Ireland, who has expertise in environmental governance, rights and international conventions that affect local public processes. We're going to talk about something that sounds technical, the Aarhus and Espoo Conventions, but which actually go to the heart of whether ordinary people such as ourselves have a real voice in environmental decisions. So, Laura, thanks a million for coming on the podcast today. I really appreciate it for you to take some time out of your busy schedule. And can we begin by asking you to tell us a little bit about your background? And let's start there.
Certainly. So I'm Laura and I'm a senior lawyer for Friends of the Earth, and I'm based in Northern Ireland, and I always have been based in Northern Ireland, and I've been working for Friends of the Earth now for 7 years. So we're involved in strategic litigation that protects the planet and supports communities doing likewise. And what that looks like in Northern Ireland is, I don't want to say it in this way because it sounds like I'm doing it down, but it involves a lot of site battles. But I feel like these site battles are like flashpoints of a much bigger issue, and that's climate change and the disruption that happens as a result of climate change. So to marginalize something and say, oh, you just get involved in site battles, well, everything starts as a site battle. And if there's many site battles on an issue, then we know it's a bigger global issue. So bring on the site battles, as long as I'm not like protecting a hedge or something, which are important. But, we look for the big site battles, the totemic site battles. And prior to this role, I worked in private practice as a lawyer, a solicitor. And although that was very interesting, I just felt like I didn't really fit the mold. So this opportunity came along and I jumped on it. And I have to say, despite all the adversity that we experience as an organisation alongside communities, it's one of the most fulfilling jobs I think I've ever had.
Oh, that's wonderful to hear. Thank you. And what about Laura Neale, that's not the lawyer, and what does Laura Neale do when she's not fighting site battles per se?
Oh my goodness. Well, you'll know that this world does consume you quite a lot. So I find increasingly the longer I stay in this job and the longer I'm immersed in this world, the more it creeps into like my private life as well, and the more it matters.
I know exactly what you mean.
I find it really difficult to just close the door on work, but it's not work because you find friendship groups and community and really fun people to hang out with. So I find that they bleed into my day-to-day life. But I'm a mum of one. She's 2.5. So that really takes up most of my time. But prior to that, I just used to do lots of things, lots of fun things, which I will get back to when I don't have a 2-year-old. But I used to surf. I used to go skiing. I used to do all those things, and I still love all that stuff. But I would say I don't think I really took the time to really appreciate and value nature in the way that a lot of campaigners that I meet do. And I'm starting to understand that the older I get, the better I get at appreciating just what's around me and slowing things down. So I'm trying very hard to do that. But I love going to the pub. I love going for dinners out. Love doing all that kind of stuff. And it's all very normal, really. There's nothing exciting there, unfortunately.
Well, thank you. It just gives our listeners a little overview of you and your life. So today we're talking about Aarhus and Espoo conventions, and to get us going in that direction, for someone listening with no legal background, such as myself, what does the Aarhus Convention actually mean to the person on the street?
Yeah, I mean, for me, when I first heard of Aarhus, and I have to say, it doesn't come up in private practice a lot. It's not a kind
No,
of thing you
imagine
hear about
not.
in the middle of your family and criminal and all that kind of law. So I was fairly new to it when I started in this job. But when I first heard of Aarhus, all I could think of was the Madness song. Our house in the middle of our street.
Do you want to give us a bar?
Absolutely not. Nobody needs to hear that. You've all suffered enough. So in a very basic sense, I could go on about this for a long time, but I'd just lose the run of myself and bore your listeners. So the Aarhus Convention and technically the Espoo Convention as well are both international treaties. So that is where two countries or multiple countries agree to sign a document that they will hold themselves to. And Aarhus in particular was named so because I think it was signed in Aarhus in Europe. I'm not exactly sure where that is anymore. I did know that, but that is a quiz question for later on. That's where it got its name from. And it is, as I say, an international treaty that's supposed to protect a person's right to live in a healthy environment. Full stop. So it annoys me from the get-go that there was that was necessary to put an international treaty in place to do that, because surely that's normal. But anyway, so the Aarhus fleshes that out, and there's a number of member states, of which Ireland and the UK and most of the EU are part of.
Yeah.
And it has at its very core three pillars, like three legs of a stool. That's how I think on it. And the first one is that it entitles members of the public to access to information about environmental decisions that will affect them.
Yeah.
Secondly, it affords them public participation in environmental matters that will affect them. And thirdly, access to justice. So what we find is the Aarhus Convention and its application in domestic law, because you can't just challenge a treaty. That's between member states.
Yeah.
We're the lowly public, but it has transcribed its way into our laws. And so, you can walk into a court here in Belfast and say that, the Aarhus Convention this and the Aarhus Convention that, and you'll be relying on local laws. But it has become a valuable weapon in environmental campaigning because of those three pillars that allow NGOs, civic society, and any person on the street to access information that's really crucial. And, that's a huge barrier to being productive in environmental issues, and to really grasp what's at stake here and to speak the language of developers and governments. So that idea of access to information is really important. And again, public participation is everything. I mean, if something is going to happen in your place or the place around you or the place that you care about, you're entitled to participate in that decision making. And then the access to justice stuff is if you feel like you have been, aggrieved in any way, you have a right to take a stand about that. Now, obviously, it's not just a blanket, I feel annoyed about this, therefore. It's much more nuanced than that. And we find that the Aarhus Convention and its application has been the subject of a lot of back and forth between civic society, campaigners and states. And every year there's an implementation report that goes out from respective member states, and they tell the Aarhus Compliance Committee, which is like an oversight body of the whole mechanism, how they've been doing, what they've been doing to make sure that these three pillars are still very important in people's lives. And civic society also has a say in that as well. We have like a rival implementation report where we call them out on the fact that a lot of what they might be saying is not strictly true. So that kind of back and forward dialogue goes on and on and on in the background. And while it's still a very valuable tool, it's still subject to a lot of debate, because the rights aren't absolute but are guaranteed in Aarhus, and they're so broad and overreaching, it's really hard to pin them down.
Right.
And that is why having like a flashpoint, such as this public inquiry into the gold mine, is a really good way to understand how Aarhus operates and what it's supposed to do. And we're seeing the application of the Aarhus Convention in real time. So that's why it's so important.
And that clarifies a lot for me, at least. So can I just push the question on a bit? So if something is described as a public inquiry into a major environmental proposal, such as the Dalradian planning application, what standard would you expect under Aarhus for the public inquiry? What would it look like, in your opinion?
Well, I mean, I would suggest that you need to put the public in public inquiry. And that's kind of my understanding of the application of Aarhus, what could be more important than this inquiry for those three pillars to be completely in perfect operation and synergy? For the public to participate in this public inquiry, they need to have access to information to allow them to participate. They need to be able to participate effectively. So saying you're allowing the public to participate is one thing, but actually engaging in meaningful participation based on the idea that you have a developer with a lot of experts and loads of money behind it, and lots of environmental law expertise and lots of industrial expertise, versus the government that has a lot of the same. And then you've got, the members of the public in the middle that are seeking to get involved. How do you make them actually feel meaningfully involved? And that's the crux of the Aarhus issue here. It's fine to give someone a seat at the table, but when they don't have an understanding of the information, or they're drowned by information, or the information is incoherent and inaccessible to an average person with no planning expertise or no environmental law expertise, then I would say that you're failing in your Aarhus commitments. But as we see with this case, it's unraveling at a rate. But the Aarhus should be a cornerstone of a public inquiry. It should be the go-to guide for how you run these things.
So in our case, the inquiry won't be streamlined online, as you rightly know, and members of the public are not permitted to record proceedings. And also children are not allowed to attend, which in practice excludes breastfeeding mothers in our group, of which we have 2 at the moment. From a legal perspective, how do these kind of restrictions sit with the participation standard you've just described?
Well, I think when we look at the test of someone on the street, hearing about this for the first time, I think that anybody could tell that this is not affording an adequate standard of public participation. But there's deeper issues that we have called out as an NGO, along with fellow NGOs working in the civic sector. There's like a discrimination here that is not just rooted in an international treaty about environmental rights. Sex is a protected characteristic. You shouldn't be discriminated based on your sex. And yet we see the arrangements here facilitated by the Planning Appeals Commission as being discriminatory to women. The frustrating thing for me is the lack of streaming, the lack of online witnesses, so virtual appearances of witnesses, and the kind of very arbitrary way in which security handled people in the audience. They could be rectified so quickly. If you don't want to entertain the idea of lots of children in a very serious place, and as a parent of a 2.5-year-old, there is no worse place I would want to bring her is to a public inquiry, because she's feral at the best of times in the best possible way, and she'd be swinging off the lampshades. So, but at the same time, I wouldn't want to not be afforded the opportunity to have my say. So that's the bind you're in. And if the PAC really wanted to include people, they could just flip any one of those switches and transform things. So they could stream things online, for instance, which means that people with childcare and responsibility, or people who can't get time off work, it just doesn't extend to women. It extends to a lot of people. Most people who can't afford to take 6 weeks off work to sit in a centre in Oma. That would afford them the opportunity to be engaged in the process, but they won't do that. And the frustrating thing is as well, is that they have done it in the past for other inquiries.
That's right.
Or, yeah, and for general planning appeals, it has been facilitated. And as we know, post-COVID, these arrangements are in place and they work. People can stream things online. They can watch along. And the thing that underscores the whole notion of it to me, aside from the fact that it's potentially discriminatory, that it denies the public their opportunity to be involved, is that there's no rationale for it.
Yeah.
We have asked repeatedly as an organization, you should start streaming, you should record proceedings for people to catch up on, you should do this, that, and the other. And they have said no, but it's a no full stop. We have settled the procedures. And
Yeah.
I want to know why. Why? No, why? Why have you decided this is the right way to do? Because you're making things deliberately difficult for yourself, because there are going to be questions about breastfeeding and children. And it's like you could flip any one of those switches, transform it, and fully include the public.
Yeah.
You know?
It's really interesting because we were at a hearing there with the PAC on Wednesday, and it was online. People were able to access it, and which was nice for the people who were able to access it. But so why isn't it? And is it being influenced by someone else not to have it online? You bring up a good point there. I just want you to say something a little bit more about it. Lack of online witnesses. Can you just say a little bit more about that?
Well, because the inquiry hasn't really kicked off proper, and I'm pretty sure we'll get to that at some point, but just as a footnote, the initial kind of procedures and how we're going to run things type discussion was streamed online. It was available for some time after that initial meeting of the PAC. So we know they have the facilities to do it. We know that they're adequate and they could do it, but they're just refusing to for some unfathomable reason. If there is a reason, please tell us, please understand and tell us or explain to us, we're entitled to that. And what creeps in its stead then is a distrust of the process, which you've just highlighted. For why reason? What else could you possibly have, that would stop you from streaming things online? If there's a valid reason, please let us know and we'll consider it. But yes, in terms of witnesses, so what we have at the minute now is a planning public inquiry, which is to be held in the place where to be affected by the environment, by the proposal. So it's not to be held in Dublin or Belfast, and that's right. It's to be held in Omagh, which will be impacted by this gold mine should it be granted permission. So that's right. However, it is a creature in its time. So you have to go to the Stroll Arts Centre. You have to be there. You have to bring all of your papers, all of your people that you need to speak. They all have to be there in time to speak to a specific timetable. There's no remote witnesses, none of that stuff. And that it just feels very old school. It feels like, we're doing something like 50 years ago when there wasn't the modern tech that we have, but it's actually prejudicial to members of the community, and also I would say NGOs as well, because when you're looking to speak to something that is, that warrants a certain level of expertise, you're going to need an expert witness to come in and speak to that on your behalf to give you legitimacy before the Planning and Appeals Commission. And that's something that happens across the board. It happens in courts as well. You get yourself an expert witness, someone that knows more about the issue than you do, that proves your point or speaks to something that you're concerned about. And we're a small place, and there aren't many gold mining experts on the island of Ireland, particularly to speak to the adverse effects of gold mining, which we know there are many globally. But it just so happens a lot of those people learn about the adverse effects of gold mining because they are somewhere else other than Northern Ireland or Ireland.
Very good point. Yeah.
Yeah, so they're mostly located in far-flung countries across the world that have been, the victim of gold mining operations. And you need to get them then to a small arts centre in Omagh, and that's incredibly, expensive,
Yeah.
and B, impractical, considering that we were all set to go last year for 6 weeks. Everybody had brought their experts or had their experts flown in, and the whole thing collapsed. So what do you do? Do you send them packing back off to where they came from at expense to you again because someone has forgotten to do something that's vitally important to the validity of the inquiry? So the idea of having remote witnesses, because we have this technology available, would be so much more efficient in terms of having people with authority able to speak to these issues that communities want to have their voices heard. And it would facilitate that. And the issue is, I understand that, the preference is always to have people in person. Like that's, it's important that these things are done up front for transparency. But we've managed through COVID to do things like this. And a lot of, the kind of virtual remote attendance kind of practices and procedures endure, even in courts. And they're not just a free for all. You have to ask for permission. It is granted in certain extenuating circumstances for you to appear remotely. And it's just a very valuable tool that could be utilized here, and it's not. And it's just causing great impracticalities for communities, for NGOs, and people who do not have the resources to have the expertise right there in the room at the time for 6 weeks, potentially more.
Yeah, and that has been our experience all the way along. We have one expert coming in from the States, and even the way the timetabling is done, he has to come in at the start of May and at the end of May, and he's 17 days in between where he'll not be needed for a particular topic, for the topics, but here he is having to stay until his date comes up again towards the end of May. And of course, there's the expense of having to put him up and air tickets and all that. And also we've, folk from Dublin and other places, and they all have to be put up by us, and it doesn't make it easy for us. Moving on, and a little bit off tangent, under environmental and human rights laws, are there circumstances where restricting access might be justified? And how do you assess whether those restrictions are proportionate?
Well, I mean, that's a really interesting question, because that goes to what I'm speaking about, in that if there are justifications for this, tell us. So, if a blanket no is the most frustrating thing, and as I say, we have written to the PAC, who organises who is charged with organising and hearing the public inquiry, and said that, look, we have concerns about accessibility, of this so far. Stop, have a think, implement these changes. They're free to do. Like, a streaming service is not expensive. They're not. If it doesn't work, stop it. Roll back on it. But if you are adamant that you want everybody to be there in person despite the adversity against them, explain your rationale. Because based on your question there, Marilla, like, human rights law in particular is always a balancing act, because your rights aren't absolute. Because
right.
There is no one, like, I can't say that my right to life trumps your right to life, and therefore, anything that I'm doing that protects my right to life prejudices yours. Mine is more valid than yours. And most of human rights law that we see is about the courts apportioning this balancing act between the validity of rights versus the state or those people who the state represents. So I understand that there may be reasons for the way in which the inquiry is deemed to be conducted at the moment. But we need to see what those are. If you're talking about a transparent inquiry, if you're not going to allow streaming, if you're not going to allow remote witnesses, if you're not going to then afford people the responsibility to bring their children or their, anything that may be holding them back, if you're not removing those barriers as well, what's the reason? Why?
Yeah.
What could cost, because I can't think about what they could be. And I have thought, what's the rationale for this? Why are they being so driven to this one way of doing things and not exploring other options, given how controversial this is, given how sprawling it is, given how huge it is, given how easily it could all come crashing down? Surely you'd want to afford the most transparency. And yet they're just doggedly sticking to this, the procedures have been set angle. It won't stop us raising those issues, because I feel like as this goes on, they will manifest, and the problems that are associated them with will manifest more and more and more. So it's that drum that we'll keep banging. But I mean, I couldn't fathom why restricting access might be justified. I can't think right now. But that's there may be a reason. But just tell us what it is.
So if participation is technically allowed but practically difficult, does that, do you think, undermine the spirit of Aarhus, in your opinion?
Absolutely. Absolutely. I mean, there are so many subtle ways that you can undermine the spirit of Aarhus. Do you know, you can afford someone an opportunity to be at the table, but drawing them in information. I alluded to that in the and earlier in the discussion. You can, you know, maneuver in ways that you understand perhaps as a planning expert that will deliberately bamboozle the general public. Um, there are ways that you can be really subtle about it, but this is so overt. You know, it just feels like, those three cornerstones of information or of information, public participation and access to justice are really undermined by this process from the get-go. And we haven't even got into the detail yet,
Mm-hmm.
and that's really frustrating, because what does that say about the validity of the process, the decision which then flows from it? If we're having issues like this, which are fundamental to the hearing of the inquiry, and they're not resolved before the
Yeah.
thing even starts again, where does that see us at the end of the inquiry? How are we going to feel
It's going to be
about?
a hell of a journey.
Absolutely. That we're ready for. But I just feel like there's so many small fixes that could be in place that aren't in place, and there's no valid reason why. And it does undermine the Aarhus Convention.
So moving back to the Espoo Convention for a minute, can you explain you've already explained the Espoo Convention, but when cross-border environmental impacts trigger additional obligations, could you talk a little bit around that in relation to the public inquiry?
Yeah. So I don't really think of from the arts bandwagon there, but because it's something that I think is so obvious in this particular case. But Espoo as well is that is a place in Finland. I do know that, and that's where the Espoo Convention was signed, and that is about transboundary like communication in relation to an environmental project that is likely to have significant effects on another state. So that sounds really complicated, but it's like kind of like saying keeping your neighbors involved in something that might infect them. It's as
Going on
simple as
over the
that.
fence, yeah.
Exactly. And it sounds like it is quite ancillary to the idea of a gold mine, but when you actually think about the sprawling nature of this gold mine, um, and how we operate on this island, of course, there is going to be a transboundary concern that will affect people in the south. We've got shared rivers, we've got shared air, like that part of the world is very close to the border. Like there is a lot of connectivity there. And what Espoo Convention does, again, you can't just rock up to Espoo in Finland and say, someone's breached the convention, like get the blue lights going, like this is terrible. It's much more subtle than that. So Espoo is transcribed into national laws. So our environmental impact assessment laws, for want of a better expression, will be compliant with the Espoo Convention. So what that requires, and I'm paraphrasing here because I could be at this all day, is it requires the North to notify the South that this gold mine is happening, and then for the South to inform the people that live there that they have a right to be involved and to have their views known. And you'll know yourself that the issue of transboundary communication caused the gold mine inquiry to collapse last year.
Yeah.
Because it wasn't done. It wasn't that it wasn't done. It wasn't done adequately to the letter of the law. And all the parties in the South that should have been informed weren't informed. That was recognised and the whole thing collapsed. And then everybody that was entitled to be informed in the South was informed in terms of state government type organisations. And then there was a new consultation run that afforded an opportunity for people in the South, whether they be NGOs, citizens, anybody to have their say as well. So now that's been included. We're back on the rails again, figuratively, and we should move on. But the idea that kind of vital thing was overlooked, even in the detail, because there was an element of it done, a transboundary consultation. I think they consulted with the council in Donegal.
That's right.
But that's not what the law requires them to do. It's much more detailed than that and much more sprawling than that. So that's been corrected and we're back on the rails again. But it's a pretty fundamental thing. I mean, the person on the street can tell that this gold mine will have implications for people in the South. And I think the groups that campaign on this issue in the South are entitled to their views as well, you know? So, the fact that that was just kind of circumvented is really frustrating and doesn't set us in good stead for the resumption of the inquiry if that's the kind of thing that they're overlooking.
So I'm Joe Bloggs in the South, and I'm feeling that the public process has fallen short of Aarhus and Espoo. What would be the sort of first steps or a mechanism to challenge that? You know, where would I start if I was going to challenge that? You don't need to go into every detail, just an overview.
It's your first letter to so there are compliance mechanisms within those international treaties. So there is, for example, an Aarhus Compliance Committee where you can issue a complaint. Friends of the Earth have issued a complaint in the past to the Aarhus Compliance Committee, and they can review whether a state has obliged by its obligations under Aarhus, for instance. I think there might be something similar in terms of Espoo, but I'm not entirely sure. But those things take a long time. And what that is an entirely separate scrutiny process. And it can take years. So that's one avenue that you can pursue. But if you were to drop everything and pursue a complaint to, you know, the treaty bodies themselves, that's going to take up a lot of time. It's not going to get resolved in the time that this inquiry runs. Right. And you'll miss your opportunity to implement directly into the inquiry. What we have done as an NGO is complain directly to the PAC. And we've, as I said, we've written to them a number of times outlining our concerns about the procedural aspects of the planning inquiry as it's intended to run. And we've been flatly told, you know, everything's settled, just stop writing to us. But we will continue. But I think it's important to kind of flag those concerns all the way through, because what you're doing is, like, I think after letter 1 in the PAC said, we're not going to change our procedures, we still kept writing because we're not writing to the PAC anymore. We're writing to the wider, public. We're leaving a breadcrumb trail for us to look back on and say, we called this out all the way through. You had an opportunity. We told you this wasn't going right. And we want our concerns noted. So that's kind of the position that we're in at the minute. And I would suggest that if anybody feels that their rights are being prejudiced by the application of this inquiry or how it's intended to run, that you mark that you make your grievances known, but you don't let it distract you from engaging in the process insofar as you're able to.
That's a good place to get started, and much to mull over there. And there is a very, very big discussion going on through all our groups at the minute around this. If anyone who's feeling shut out or frustrated about this, what would you like them to understand about their rights?
That they have them, that they're there, and they are supposed to be utilised. And they're I don't think everybody is meant to be a campaigner in the way that you guys are, that frontline row. Sure. I'm certainly not. Sure. Like, I'm paid to support you guys in a job that I love, and I love doing it. But am I that person that would be brave enough to do what you guys do? Probably not. But the tenacity that you show as groups is just so inspiring. And I think that no matter how much they try to grind you down, like, know that your rights are there, that they're there. You can act on them. It might be frustrating. The process might look like it's weighed against you, and to a certain extent it is. But you just have to keep going at it. You know, you have rights, and people can't take them away without a fuss. You know.
Yeah. So it was good to remind ourselves of that, and it feels good to have people like you behind us, to be honest, as well.
Well, Marilla, it's as simple as this. Like, you have as much right to be there as anybody else in the room. Yeah. Nobody's extra special important, you know. Yes, there's this idea that, like, you know, with the Planning and Appeals Commission, that you're a third party objector or whatever kind of terminology they use, but your voices can still be heard, and they should be heard. And the kind of like intimidation of, like, you have lesser of a position at the inquiry is just not valid. Not in something like this, not at all, because it's a public inquiry. It's down to you guys to put the public into public inquiry.
Coming up to our second but last question. For stepping back a moment from the legal detail, what do you think it's saying about our democracy going forward if environmental decisions of this scale feel inaccessible to ordinary families?
Oh, it's a big question, isn't it?
Yeah, it is. Yeah,
That
it
is a
is.
big. I'm gonna be thinking about that all night. What does it say about democracy? Do you know? I don't know. I wish I had the answer to that. I don't know. It does scare me a wee bit. But do you know what actually scares me? It's like how much of this has gone on in the past and has been unnoticed and
That's right.
undocumented. Like
Yeah,
we feel like this is an exceptionally, egregious thing. How dare they put a gold mine in Sperrins, and how dare they, deny us an opportunity to have our say, and how dare they limit our opportunity to have our say, all those kinds of arguments. But it makes me wonder, like, how many things have gone on that, have just slipped under the radar
yeah,
because people don't know enough
yeah,
to raise the issues or don't know that their rights are being prejudiced or that the things that are happening, how much unfairness have we taken in the past just as read, you know?
yeah,
That's
yeah,
what concerns me. So I don't know whether I'm a massive history nerd and I don't know whether it's because I just tend to be a bit happier reflecting in the past. But that's I look back and I think, my goodness, like if these are the issues that are coming up with us and we're tackling them together, and we're raising a big stink about it, how many other people weren't afforded that opportunity in the
yeah,
past, you
yeah,
know?
yeah.
And I don't know what that says about the future, but if you forget the past, you can, what is it? What does it say? If you forget the past, you're doomed to relive it. Something like that.
Something like that.
Something like
Hopefully
that.
not. Well, I can think of a number of environmental disasters which, if possibly no more was known about them at the time, we wouldn't be in the position today. For example, Maboy Dump, for one, and Lough Neagh to number two. There are things that have gone on under the community noses without anyone really being able to say or do anything about it. But perhaps
Absolutely.
perhaps those days are changing. Come to our last question. What gives you hope about all of this?
Do you know, the fact that you and I are sitting on a Friday afternoon talking about this stuff, do you know, like, and that's a conversation that we're both really passionate about, and the issues are really that we're really passionate about. And I know that we're not the only people talking about this stuff on a Friday afternoon, on Friday afternoons, and any other afternoon. Like I know there are people in the pubs up and down the country, and coffee shops, and houses, and kitchen tables talking about this stuff,
Yeah,
this thing in particular. And that gives me hope to know that
yeah,
the idea that you can just do this stuff and nobody raises an eyebrow, I think is a fallacy moving forward. I think we have a highly informed public now, and a campaigning groups that are highly informed, highly sophisticated, and are capable of bringing it with, it's not a David and Goliath so much anymore. I know it feels like that, but the energy and the enthusiasm and the connections that campaigning groups have in relation to this gold mine proposal, um, is what gives me hope. Like even though the odds are stacked against you, and even though all of these mechanisms prevent you from taking part, you're still there, front line, giving them, I'm not going to swear, but saying your bit. And I just think that's really inspiring. And I think you can take that in any context, even outside of the environmental context. And that's a fantastic story. Like this is something I'm going to be telling my wee one when she's old enough to appreciate it, about how proud I was to be there
yeah,
and watch all that unfold. And once you see that up front, it's really hard to get it out of your mind. Like I remember speaking to campaigners long time ago, and they were talking about the state of the place, as we do often,
yeah,
and they were like, wouldn't it be great if you could just unknow the things so that you're oblivious to it all and you could just continue going on in your own little world. But once you know, like, you know of all these harms that are being done, and you just can't forget them. But I would say that's a really tragic thing, and it's quite sad. But also, once you know about all the class stuff and the class people that exist in this little world, it's really inspiring. And you think, my goodness, I am so glad that there are people out there doing this stuff. A, so that some people don't have to, but B, just so that someone is there on that right side of history, as far as I'm concerned.
On that note, Laura, thank you very much for a brilliant conversation. As I said earlier in the conversation, I'm really glad that we've people like you behind us, because I don't know where we'd be without you today. For all the work that you and Friends of the Earth and others like you have done in a support system. So thank you.
It's absolute privilege, and there's nothing better that I like as well, in a weird way, of just, knowing that there's a meeting with you guys, that we're all going to talk about something, and that, something's going down, we're going to do something. It feels so wonderful. It just feels like, regardless of the result, the fact that we're able to do something is great. And it's a privilege.
Thank you.
All right. Thanks.
Well, there you go. That wraps up another week. A really insightful conversation with Laura, helping us lay the legal framework alongside what people here are experiencing on the ground. It occurs to me that conventions such as these are meant to be real, not just written down somewhere. How can a public inquiry be called public if not everyone is able to participate? The practice of participation means that if everyone in Donegal, or indeed the rest of Ireland, wanted to follow these proceedings, then technically it's not possible. And when mothers can't attend, exclusion becomes very real. We know that the right of participation exists. The question is whether we can experience it in reality on the day. We have to ask ourselves, is the spirit of environmental legislation really being honoured here? Environmental decisions affect water, air, land and future generations. Our full participation cannot be conditional. I feel this discussion will not end with this episode. If this conversation has struck a chord, you might want to go back to episode 7, Human Rights in the Hills, Defending the Defenders, and episode 35, When Public Isn't Public, where we explore these questions from different angles. You can pick up the links in the show notes. We'll be back again with another conversation soon. For the air we breathe, the water we drink, the earth that supports our community health, for generations to come, we hold the line.